A single signature can legally bind a third party, transfer fortunes, and create massive liabilities, all without the principal ever stepping foot in the room. To understand how this mechanism operates, we are conducting a forensic audit of the Philippine New Civil Code, specifically Title 10, Chapter 1. That encompasses Articles 1868 through 1876. Mastering this specific 9-article framework allows you to spot hidden contractual issues, avoid fatal bar examination traps, and map the precise mechanics of agency. Agency is a dangerous legal fiction. It converts actual physical absence into binding juridical presence. Article 1868 establishes the core algorithmic definition. By the contract of agency, a person binds himself to render some service or do something in representation or on behalf of another. The absolute essence here is representation. The formation relies on 5 mandatory pillars: consent, object, representation, authority, and consideration, tracked by the mnemonic CORAC. There are strict boundaries to this representation. Strictly personal acts, like executing a will, or inherently illegal acts, cannot be delegated to an agent. When analyzing a problem, always verify the intent to represent. An agent acts on behalf of the principal. An independent contractor acts on their own behalf. Examiners frequently test this by placing the word agent in a contract header. Disregard the title. The legal reality relies entirely on the mechanics of the relationship, not the labels chosen by the parties. Article 1868 serves as the master source code. Without true fiduciary representation, the rest of the agency framework collapses. Moving to Article 1869, the Civil Code dictates that while oral agency is the general rule, the form ultimately follows the function. We use the mnemonic EIOS: express, implied, oral, and specific form. Implied agency requires no spoken agreement. It is formed through the acts of the principal, their lack of action, or their failure to repudiate the agency. The Supreme Court ruling in Conde v. Court of Appeals provides the exact formula. Silence combined with actual knowledge triggers an implied agency. The principal knew another person was acting on their behalf and chose not to stop them. However, you must establish that knowledge. Agency is never presumed. The burden of proof rests entirely on the person alleging that the agency exists. The law heavily penalizes willful ignorance. Knowing an impostor is acting in your name and doing nothing to stop them legally validates that impostor's actions. Under Article 1870, agency requires mutual consent. The agent must intentionally accept the mandate. This acceptance is deduced from their actions, mapped by the EASY mnemonic: express, acts, silence, or inaction. A common pitfall is assuming that remaining silent to an unsolicited offer from a complete stranger creates a binding agency. It does not. A duty to respond must actually exist in the surrounding circumstances. This changes entirely under Article 1871's face-to-face proximity rule. When the parties are physically present, physical delivery of authority demands immediate action. This is the PDR rule: present, delivery, and receipt without objection. Physical acceptance of the power of attorney perfects the contract instantly. It binds the agent even if no notary public intervened in the execution of the document. Physical proximity removes the excuse of ignorance. Receiving authority face-to-face forces an immediate legal choice: reject the mandate loudly or be bound to it silently. Article 1872 addresses parties who are geographically absent. Here, the default legal posture is protection. Between absent persons, silence equates to rejection. There are 2 strict exceptions to this default, tracked by the ATH mnemonic: absent, transmits power, habitually engaged. Acceptance is implied if the principal physically transmits the actual power of attorney, or if the request relates to the business the agent is habitually engaged in. To navigate this in exam scenarios, immediately verify the offeree's profession. If a letter is sent to a professional real estate broker to sell land and they ignore it, their silence legally equals acceptance. You must distinguish a mere letter of inquiry from the actual transmittal of legal authority.
Asking someone if they want to be an agent does not trigger the exception. Distance acts as a legal shield against unsolicited burdens, bypassed only by physical documents or established professional habits. Article 1873 explains how public perception creates binding legal reality. Specially informing third parties or utilizing public advertisements legally clothes an individual with actual authority. This invokes the doctrine of agency by estoppel, governed by the SPR rule: special info, public advertisement, and rescinded in the same manner. The Supreme Court ruling in Rallos v. Yanko makes the application clear. If an agent is announced via newspaper, a private letter of revocation sent only to the agent is completely useless against the general public. Do not confuse internal agency rights with external liability. Even if the internal contract is terminated, the principal remains fully liable to innocent third parties who relied on the unrescinded public notice. Public perception becomes a legal cage. A principal is trapped by the exact medium they used to broadcast the relationship until they use that same medium to revoke it. Article 1874 establishes an absolute formal barrier. When an agent executes the sale of a piece of land or any interest in that land, their authority must be in writing. The legal consequence is absolute, mapped by the LAWV mnemonic: land, authority in writing, otherwise void. If the authority is only oral, the resulting sale is entirely void, producing zero legal effect. In your analysis, aggressively use the word void. An oral land sale through an agent lacks legal existence from the start, a stricter consequence than the unenforceable status usually found in other statutes. Also, note that this requirement applies exclusively to real estate, not to personal property like vehicles or jewelry. The Civil Code ruthlessly protects real estate titles. Oral mandates shatter completely against the solemnity of land ownership. Shifting from mechanics to economics, Article 1875 establishes the modern baseline: agency is legally presumed to be for compensation. Think PFC, presumed for compensation. To earn that compensation, the agent must be the procuring cause. They must be the direct foundation that brings the buyer and seller to a meeting of minds. Effort does not equal pay. An agent can exert massive effort and incur heavy expenses, but if the deal fails to close, they earn zero commission. The singular exception relies on equity. If a principal revokes an agent's authority in bad faith right before closing to avoid paying the commission, the agent is still entitled to compensation. Agency is a results-based economic engine. The law rewards successful execution over mere effort, unless the principal attempts to weaponize the revocation. Article 1876 categorizes the scope of an agent's power into two classifications: general, comprising all the business of the principal, and special, comprising one or more specific transactions. The distinguishing metric is the GAS mnemonic: general equals all, special equals specific. The true test is the continuity of service versus an ad hoc, isolated engagement. Do not assume an elite expert is a general agent just because of their prestige or high compensation. A single monumental task executed by an expert is still a special agency. The scope of an agent's power is not determined by their title, but strictly by the volume and continuity of the transactions they control. Agency begins with absolute fiduciary representation under Article 1868 and is dynamically formed by acts, silence, and geographic presence through Articles 1869 to 1872. This framework is reinforced by severe legal fail-safes. Principals are trapped by public estoppel in Article 1873, and unwritten land sales are avoided instantly under Article 1874. Your strategy requires strict forensic deduction. Never presume the relationship. Always verify formal writing requirements and identify the scope of continuity. Treating the Civil Code as an interconnected operating system provides absolute forensic clarity when dismantling complex legal liabilities.